There are many. I represented some who escaped from prison here. I expect them in this documentary. So to show that it's not about escape of prison, why is it not encapsulating all the escapees that are within the borders of the Republic of South Africa or in any prison? Rather, it focuses on one single individual, that is Mr. Thabo Bester. So that shows that this is not about prison escape general documentary. This is specific to the life story of Mr. Thabo Bester that we are fighting against. Now, my lady, there is also an issue that was raised by my learned colleague to say Thabo Bester was not given a right to reply. There is no right to reply on our law. I have written something, we have written something beautiful here with my learned colleague on our answering affidavit, on our replying affidavit to say, on paragraph 42, what we have titled as right to reply. On 42.2, it says, I submit that even though Netflix is currently not required to comply with BCCSA standards, it is common cause that ethical documentary standards ordinarily make provision for affected persons to be afforded an opportunity to comment or tell their side of story. On paragraph 42.6, it says, I believe that had the legislative envisaged the existence of streaming companies such as Netflix when drafting a BCCSA policies, he would have included the necessary provision requiring Netflix to conform to the provisions of the BCCSA. In the absence of same, I am asking the court to intervene as to oversight has allowed the respondent an opportunity to act in a manner that violates my constitutional right, which opportunity Netflix has taken with both hands and at all full speed. My lady, this case that I'm arguing before you is one of the most important cases in our legal system, because we do not have any case where a podcast or some online broadcasting company needs to be given a responsibility to give a right to reply. It is in this case that we will see whether the court realizes that freedom of expression needs to be balanced with a right to reply. Because also a right to reply, it's still included in the freedom of expression to say you cannot speak about me without me replying. I heard that one of the parties here was given a right to reply, but we were never given a right to reply. Mr. Thabo Bester was never given a right to reply. If he could have been given and denied it, that was a different case. But nonetheless, no right of reply was given. So also, in so saying and doing, that also affects his right adversely, because he should have a right to reply. So having said that, my lady, I will say on the right to reply, we do not expect Netflix to abide with the Broadcasting Commission standards of South Africa, because Netflix is a Netherlands company, but we cannot also allow Netflix to come from Netherlands to violate rights of citizens of this country. Because should we allow this broadcast to proceed? We are simply saying an international company can come and violate the rights of our people. I am sorry to say this, but I will have to say it because it's in my mind. We are also having another Jan van Riebeck coming in a camera form, rather than a gun this time. My lady, I will proceed. When we are dealing now with an issue of, a documentary being flighted, we are speaking specifically of saying the damage that Mr. Bester will suffer in this regard is the one that says if he wins a case and he comes out innocent after a trial, where will he live? Who will he talk to? How will the public be viewing him? And what will the media be seeing him as? We are saying let the trial proceed and end whatever that needs to be said, it be said in court. Then it will come out clear into the public. With this documentary, will never oppose it. I want to close my reply. Let me check at one point here. I've addressed the right of reply, I've addressed agency, I've addressed harm. Let me labor a little bit on harm. It's very important. Irreparable harm. There is a very beautiful case that we have mentioned here in the on paragraph 43, what we titled this irreparable harm, 43.2, the case of print media versus Minister of Home Affairs, where Constitutional Court considered whether prior restraints on publication, though classification before distribution, were constitutionally permissible. The court recognized the prior restraint is generally viewed with suspicion in our Constitution order. That's paragraph 63. However, the court affirmed that prior restraint may be justified where publication poses demonstrable and substantial risk on prejudice. That cannot be remedied after fact. That cannot be remedied after fact, paragraph 66. The court stressed that the adequacy of alternative remedies must always be assessed in light of the nature of threatened harm. So the court stressed that the adequacy of alternative remedies must be always assessed in light of the nature of threatened harm. So a threatened harm and then the alternative remedy. My lady, according to my learned colleague, he says, let's flight this broadcast, 300 million see it, who will pay Mr. Bester? We would have made our millions. That's what he says in simple terms. We would have made money, we'll pay him. That will be a substantial redress. The question I'm having, my lady, what is the price of a man's dignity? How much does a man's dignity worth? 5 million, 3 million, 30 million? That is a question we cannot answer at this stage, because a harm is done. When a harm is done, there is no money that can retract it. He can be given money, drive an expensive car, stay in a beautiful house, but the bottom line is that he has already been labeled an escapee, he has already been labeled a fake death host, he has already been labeled all these things. And that's what the court needs to look into. And my lady, there is something that I've learned about, there is somewhere on the papers, I'm not sure which part of the papers of the respondent, but I will speak anyway. I think they are speaking about where they say they cannot postpone this broadcast. It's in their company policy that they can't postpone this. It must proceed. My lady, they have postponed in the past. I will show you. On our answering affidavit, paragraph 44, Netflix history, we title something there, Netflix history of postponements. Number one, in 2014, Netflix postponed and ultimately cancelled Bill Cosby comedy special and Bill Cosby 77 following widespread sexual assault. They did postpone or cancel. In January 2025, Netflix delayed the release of Meghan Markle's lifestyle series With Love. Meghan, in response to devastating Los Angeles wildfires, explaining that's the show actually, that during 2023, WGA and SAG-AFTRA strikes in USA, Netflix postponed multiple films, Damsel, Lift, Players, Spaceman, because the circumstances prevented a responsible release. Finally, in COVID-19 pandemic, Netflix delayed numerous production and stage release schedules worldwide. So, by having said, given 4 or 5 cases that I've given of postponement, Netflix does postpone. So even the Thabo Bester, The Beauty and the Beast and the Bester, The Beauty and the Bester documentary can still be postponed for the trial to end. Why is this one is so special that it can be postponed, but others were postponed successfully? And my lady, let me check here if I have something to say. But Let me check quickly. I think I have something here that I must make a submission of before I sit down. My lady, let me say this. With a very serious attempt to differ, that you will differ with me perhaps if I say this. The right to freedom of expression must be balanced with the interest of justice. The right to freedom of expression must be balanced with the interest of justice. If the freedom of expression works against justice of others, we need to look very strongly at that freedom of expression. Having said that, my lady, this becomes the end of my reply, as the court pleases.
Thank you. Yes, counsel.
My lady, I'm going to try to be brief and structure the reply. And the structure of the reply, it's simply just take the issues not dealt with, and then I'll deal with the distortion of what we didn't say and what certain things that were said about certain letters did not say. And I'll also highlight the section 9 and pass on it because your ladyship invited us. And then I will deal with the delayed agency. Left to the last.
No, I didn't invite you. I alerted you to the fact that you didn't address it.
I will respond to that. And then I will deal with the issue of delayed agency. Last. In the issues not dealt with, nothing was addressed about what we say, the true intentions between the parties to the contract, which is not disputed. The true intention is not that of which is then reduced in writing, and we made out a case for that, for court to draw inference. One of the inference that we draw is the letter that was relied on. This is the letter. My lady, I hear people whispering. It's disrupting me.
I'm sorry, I didn't hear.
Yeah, it's coming from this side. Perhaps they will not continue. Yes. Then now, it's going to be addressed by the letter so-called the right of reply, and not even contextualizing how did Dr. Magudumana know about that particular letter. So I submit that issue of common understanding was not addressed. And the reason it was not addressed was to lump these cases of Mr. Bester and Dr. Magudumana in that they don't have a right. We accept that it's an inherent right, but we did argue that the case of Dr. Magudumana is different. She has that particular right, and at the point of this application, which is a prima facie, which is an interim, she must only demonstrate that, even if it's open to doubt, she explained that particular aspect. And this takes me then to this particular letter that when she made an allegation, she gave an history in the founding papers of how she met Mr. Mgudlwa and how she instructed Mr. Mgudlwa and specifically Mr. Machini with the power of authority. None has the power of authority than Mr. Machini. Then she says in the papers, the common understanding between the parties, which is then the true intention that the court will give effect to in Part B, is that she will have a right to reply. And you can't say that in the air. You put facts. Then the facts we say are confirmed in this particular letter that is attached at page 001-37. This is the letter of Netflix on the 31st, arguing that, okay, actually we've given we say that your client doesn't have that right of reply, but in actual fact, we have given your client a right of reply. And what they do obviously she doesn't have a WhatsApp. They attach WhatsApp of Mr. Mgulwa and their representative. They want this court to draw an inference without any basis that it actually reached Dr. Maguduman. This was the question that was supposed to be sent to Ms. Maguduman for her to comment. And Mr. Mgulwa, in the WhatsApp text that are posted here, never confirmed that he took, in fact, he undertook that he will take these questions and he will hear what would Ms. Magudumana say. In this WhatsApp text, none lends to this conclusion that it reached Mr. Maguduman. There was an attempt from Mr. Mgulwa, but this never reached Mr. Maguduman. And there's no evidence that can controvert that. But what is important, you craft a letter to try to achieve something, you achieve a different purpose, which is fatal, self-inflicted wound. In that particular letter, there is Annexure A, the letter on 001-37. There is what is called Annexure A. And that's why we're saying that you look at what Dr. Magudumane is asserting. The common intention that you must give effect to is that I have a right to reply. They are not coming to this court and say that does not exist. In fact, they act contrary to what they are saying now. They try to give effect to the true intention that they entered into with Dr. Maguduman. Their agent says the following. Dear Bonelela, that is Mr. Mgulwa, as per our previous discussion, we are conducting due diligence on all archives provided to us in accordance with our archive license agreement and have started the process of production legal checks more broadly. Engaging with the person that you have no obligation to engage. Production legal wants us to afford Dr. Magudumane the opportunity to comment, own words, on certain public domain alleged storyline we may report on. Before we report, we would like to discuss the theme we intend to cover and seek inputs from this. You come to court with almost boldness and alacrity. You say there is no common law, there is no law that confers anyone, Mr. Thabo Bester, Mr. Magudumane, Dr. Magudumane, in terms of your own letters, you are literally recording the intention as you understand it between the parties. Then this is what is important now. We propose the following attached request for comment on the 25th of September, which will not be in the form of specific question we would have otherwise like Dr. Nandipa. Should you find any topics uncomfortable to address due to the ongoing trial. So that is at the center of this arrangement. It's not just fluffed up in this particular letter. It's at the center. Or any other reason, she's obviously free to refrain. That's the spirit of the parties. You will then engage. If you don't say anything, then we don't have that information. Your trial right in terms of the arrangement is protected. Then I conclude with this one. Our intention, which intention? Story scope. Our intention is not to compromise Dr. Maguduman, but to comply with legal requirements for clearance, both locally and vice, and they speak about other things. But this is at the center. And when you look at these objective facts, remember, now when you then look at what is the true intention between the parties, you don't choose one side. Say, Dr. Maguduman is saying this, Netflix storyline is saying this. In terms of the Boots case that we've relied on in the heads of argument, I think that's the last paragraph. You looked at this objectively. These are the objective facts before you. Are you going to ignore objective facts and you give effect to a one-sided contract that does not reflect what the parties agreed? That would be a legal absurdity. Then I've dealt with, and this was the letter that was, in the submission it was said that it proves that she got the right of reply. This is the letter to Mr. Mgulwa. Mr. Mgulwa is not Dr. Maguduman. In the letter that, obviously, I won't read the body of the letter, but those WhatsApps, it's efforts. Mr. Nell kept on asking, when are you going to see Dr. Maguduman? I'm still trying. Follow-ups and follow-ups. There was no, I've seen her. This is her attitude. She has seen the question. Dr. Magudumane then confirms in the founding affidavit that the first time that I saw this letter that was addressed to Mr. Mgulwa was on the 31st of August when the instructing attorney showed her that particular letter. She was not aware of it. So that is post facto, when they've already dumped these snippets for the intended documentary. Then now the second one of the distorted events is the letter of the 8th of Jan. The letter of the 8th of Jan is used to try to then to create a picture as if like this agency was triggered from the 8th of Jan. Therefore, Dr. Magudumane stayed supine and only approached this court in September. That is far from the truth. The letter itself my lady, can I be given indulgence to just locate the letter of the 8th?
Certainly.
I'll come back to it. I'll just explain what then transpired on that particular letter of the 8th of Jan. The letter of the 8th of Jan came about under the following circumstance. The instructing attorney now for this matter informed Mr. Machini that there are rumors that Netflix is going to broadcast the documentary, which, according to the agreement, they are not supposed to broadcast if Dr. Magudumane has not been given a chance to comment and do all other things that they've confirmed in their letter. My lady, there's no page reference. I don't want to derail the court, but
No,
it's there.
I've got the page reference.
Yes. Then it says that, dear, good day, Laura. I trust you are well. I've been informed by Thabo Besta's legal team that there's a clip doing rounds involving documentary in which Dr. Magudumane's father is being interviewed. I'm told the documentary series will be shown on Netflix by the end of Jan. The said legal team furthermore indicated to me that there's a payment of 1.2 million affected to me by yourself in respect of this documentary. I have the following serious concern regarding the above. The recording of Dr. Magudumane's father without his legal team giving permission on the content is prejudicial in many respects. We respectively requested that an interview that is to be conducted in the name of our client should first receive our consent, particularly to the content of such interview. We respectfully requested and agreed that no part of the documentary should be shown before our current legal case involving our client are finalized. We specifically agreed that no part of the agreement should be disclosed to any third parties. Then, this is then followed by a complete denial that that documentary is going to be broadcast through the letter on the 3rd of Feb. It's a direct response to, I've heard that this is what you intend to do. The response, I hope that you are doing well. I'm sure that you have a lot, page 001-115. I'm sure that you have a lot on your plate with the trial coming. We have a bit of difficulty responding to your letter as we are bound by confidential agreements signed with different parties, as you will appreciate, and it's not clear from the email whether it relates to Ms. Magudumane or Ms. Sikeleni. That said, I can comfortably give you the assurance that there is no truth to the statement by Mr. Bessa's legal team. What is the truth and untruth of the statement? Is that you want to publish? They completely deny. Now a statement is that the trigger agency is that particular time. When we sent a letter, we should have come to court when they deny what we are saying. That's the trigger agency. Remember, this is done now to elevate this argument when it goes to cost. Because this elephant, this is unthinkable. A party who was supposed to come in Jan is here in September. Unthinkable. An abuse of court process, lack of courtesy. You must address those submissions based on the papers. You must then say that we didn't explain, reasonably, we disregarded. 612, you ask for deviation and then you explain the deviation. The deviation does not mean disregard. The disregard is when the explanation is not sufficient. But you can't make submission in the air. You must make submission to the explanation that was given, and you must say it's unreasonable. But there's a startling proposition that is made, that if a person is incarcerated and there are challenges that they face in seeking legal advice and attaining such, they cannot use that as an explanation that I heard about this particular aspect, I needed to have a consultation, I had a consultation on this particular day. They say that no, they cannot come and for those limitations they are barred. That's the sum total of the submission. For thus, if they know that there's limitation, they cannot even invoke Rule 612. Rule 612 is invoked for that, to explain your peculiar circumstances. What are your circumstances making you not to comply than this other one? And that's why we have these different cases between Dr. Magudumane and Mr. Bester. You will find, my lady, at paragraph 108 of the founding affidavit, you are told that there's a practice directive. We know of the practice directive. By Thursday noon, papers should be ready. If they're not ready, what must happen? You don't come to court. You do. You do. You explain why you could not file the papers by the preceding Thursday. The rule is not, if you skip Thursday, you have traded your rights. The rule is that if you can't, or if you could not, then you explain it in your papers. These are the papers. Paragraph 108 of the founding affidavit. That is explain why such practice directive was not complied with. And you will see that at 00142. She says that the 5th, my lady, when the parties reach loggerheads, when Netflix, after having asked extension to consult with their lawyers, came back with an answer that we're not engaging further. The 5th is Friday. Cannot reverse it to be a Thursday. When is Netflix broadcasting? Tomorrow. Is there any other Thursday before tomorrow? No. It's actually Thursday today. So, you follow that line of reasoning, we should have then filed the papers today. Netflix publishes, because we want to be bound slavishly to the rules or the directive. That argument, obviously, it lacked legal cogency. Then, the case law that we rely on, I won't read, it's Mokhala Kwena at paragraph 12 of the heads and Grace Venue. I've said in my main arguments, you look at the reasons why this matter was delayed and is prosecuted in this particular aspect. And then I said to this court, at every point, Dr. Magudumane, even from the consultation, not before she even lodged these papers, she kept them abreast. After they responded on the 31st of August 2025, the starting attorney says that we've only managed to secure a consultation on the 3rd. We can't respond. We will respond to the response after the consultation. And then she does that. She was supposed to come blindfolded without having attained necessary instruction from Dr. Magudumane, because this court, because it's busy, you cannot ask for deviation. That submission, my lady, I submit that it should be discarded on the facts that is before the facts that are before you. Then there is then the issue of reply unsigned in all that. That is when the respondent sent the answering affidavit for the first time, it was unsigned, because they understand that you don't have to delay and wait for it to be signed. Give your opponent so that they can be preparing. The signing, you're not going to change it, but at least the substance, give them the time. That's why they operated. So they say that they have a right to do it, but we can't do it. We send to you because it might be delayed in the commissioning. So that cannot be said that it is not good reason. Then the last aspect is that in respect to disregard to court rules, which is not disregard, it's a regard, not disregard. She regarded the court rules. After having received the answering affidavit, in the reply, she told them that, the instructing attorney, that I received the answering affidavit, Dr. Magudumane need to see it, I can't respond. She only managed, and it appears in the replying affidavit, she only managed to consult with her for 30 minutes. And at that time, she had made arrangement with the correctional service to bring the answering affidavit to the attention of Dr. Magudumani. To her surprise, at 11 a.m., where the consultation was arranged telephonically, she learned that Dr. Magudumani does not have an answering affidavit. But nonetheless, because of the exigency of the matter, she gave an overview of what this case is about in terms of the answering affidavit so that she can get necessary instruction. And she says that we had to improvise. And you're telling that you're disregarding the rule. Because if you look at the papers, you can then summarize to your clients that this is what they are saying, this is what they are saying. You have anything to say. I might not go seriatim looking at the time constraint. That's why you look at the replying affidavit. It's addressed thematically, agency and all that. So to the extent that what is said in the founding affidavit is at odds with the reply is denied. That's how it went. Then, furthermore, after filing the reply together with the heads, she explained in the further explanatory affidavit. And you'll find, my lady, the explanatory affidavit, it says 006-1. And it's just one page. This is someone who's accused of disregarding the court rules. She's explaining what happened. You must punish her for explaining. It's a catch-22 situation. Paragraph 5, it says the following. I have dealt with the challenges faced by the applicant regarding accessibility and taking instruction. That was dealt fully in the founding affidavit and the reply. As a result, even the preparation of the replying affidavit was done through improvisation, in that I had to summarize the respondent averments in the answering affidavit to the applicant, as she did not have the answering affidavit with her during our telephonic conversation. This resulted in the late filing of the unsigned replying affidavit. Consequently, the heads. As a result of the above, I'm seeking condonation for the late filing of the replying affidavit. There are typos and heads of argument as prescribed by the AJP directive. So there was a directive given specifically that parties must exchange all the papers by 4, including the heads. So she is not disregarding, she is regarding it, she is acknowledging it. And she says the following. The applicant was not willful. She had to deal with answering affidavit excluding answers of not less than 60 pages, answering affidavit, and challenges she faces. The delay in the filing of the reply and the heads was not excessive. It's less than 24 hours. The applicant has a strong prospect of success in obtaining the relief. I've demonstrated that that contract in terms of the Constitutional Court says that it will not have difficulty. So this is the explanation. It is not being controverted, but an argument must be made in the air because it's legally attractive. A legal argument that is attractive without facts is of no moment. Then now, we then deal with the issue of Section 9. I think that will be the last aspect if I did not forget anything, because these notes now. So now, you look at this aspect of courtesy. When they're saying someone doesn't have courtesy, I'll just make a reference. At page 001-142, that's a letter of September before the application was lodged, just telling them that I'm not sitting, I'm waiting for the consultation. I was just giving the reference to that particular aspect. So the courtesy even begins before the litigation. And then it continues throughout the litigation until we get to court this morning. She keeps on abreasting them. Then now, the final aspect, Section 9. You look at Section 9 with the engagement that we had, and my learned colleagues respond regarding Section 34. I'm failing to make sense out of it, but let me try. It's an attempt. You have a contract that says that you can approach the court. Because you are seen in court, therefore that contract does not exist. That's not how you must argue in court. You can't be blocked by the security because of Netflix blockade contract. When you are here to set it aside, it is that you can then access other rights. Because if you can't set it aside, then it says that you have waived your Section 35 right, you have waived any right, except for claim for damages. That is exactly why we're saying that this is dangerous about this particular contract. Because I'm seen standing here, extended screens, then Dr. Nandipal's clause blocking her has vanished into the thin air. Because I'm in court. We're in court to then say that in Part B it must be set aside and there's a strong case. And then they told you that you don't go to court because you are blocked by the contract. But when they come to court, Section 16. That's malicious litigation. You change like Cape Town weather depending on what will fit the argument. Then I close by what I started with. Krikla. Justice Krikla. And there was no meaningful response to that particular aspect. My learned colleague has assisted. So that I won't read it, it has been read. Why am I ending with it? Because all of the things that we've said, they fit specifically to the issue of prejudice. It's not only prejudice in court. There can be prejudice by public trial. And the reliance on the bail application, you are told that we are not kids. That means we are adult. It's a legal principle. If you follow that principle, Thabo Bester is guilty, adult principle. Dr. Magudumani is guilty, adult principle. Any other principle except the principle that has been agreed by the parties that she has the right to comment is not a principle. But we are not kids. They are guilty. And what is used to support that starting proposition? You go to bail application. Bail application is not making a determination of guilt. It simply says that test for bail is that it should be in the interest of justice for the accused to be released, and then there must not be a flight risk. The state can then demonstrate that they have a strong case.
I know what a bail application is. I think you misunderstood the argument. So it's public what the assertions were, and therefore the argument is it's not something new that's going to be a Netflix.
There were two arguments.
There's nothing about an adult and therefore you guilty.
There were two arguments that were made to that respect. There's the issue of being public, but also the issue of fact. When an argument is made that Thabo Bester or Dr. Magudumani are guilty, it's a statement of fact. When you say that it's public, you are saying that obviously it's public. But you were asked to then say that there are findings that are made. So there were two submissions to that. So I'm addressing the second one. I'm not concerned about this being public. It's not Dr. Magudumani's father being interviewed to testify. It's something else. It's completely differentiable. And I will end that submission there, my lady. And I'm saying that that means in respect of cost, I don't think that we even get there to the issue of de bonis with the evidence that you have of the explanation. I don't think we even get there, truly speaking. And I would not waste the cost time by answering to something that is not supported by the facts. The facts were there. We then say that it doesn't reach to that state of multing a practitioner who took reasonable steps and explained herself at every point, as the court pleases.
Thank you very much. May I just find out when is this? I'm not asking you, I'm asking counsel. When does this flight, or when does it show?
I'm told, but actually, let me ask before I give evidence. My understanding is that it's 12 midnight because it's actually being streamed from the US. So it's this midnight. So when they say it's on the 12th, they mean this midnight. I understand why your Lordship is asking me is whether you can give your judgment tomorrow. I can ask, but I don't know. I would like to help, but okay, let me ask. I just don't know.
I can do it before midnight, but then I'm not going to do it in court. Then I'll upload it and email it. I'll ask it to be uploaded onto case lines and emailed to the attorneys.
Yes, I wonder if I can't help, because it looks like it's a different time zone in the US, so which might give your ladyship a little bit more time. Apparently, it's 12 Los Angeles time, which means it will be 9 a.m. South African time tomorrow.
Okay, I can give the judgment at 8:30.
As you please.
The judgment will be reserved. Counsel are excused from attendance, but the attorneys must please be here. Court will adjourn.